Hey everybody, and welcome back to the channel. If this is your first time here, thanks for tuning in. Today I will be going over the top 5 must-do steps to take after moving to Florida to establish residency and save money. If you're looking to declare Florida as your state of residency to take advantage of benefits like no state income tax and the Homestead exemption, it's important to know that these benefits aren't automatic. In this video, I'll walk through the key steps you need to take after moving to Florida and why they and the order you do them in matters. I'm Robin Vakai, the broker-owner of Beach Bay Real Estate and a certified financial planner for the last 25 years. You're watching Suncoast South, where I share the real story of the Venice housing market, neighborhoods and communities, costs of home ownership here, including CDD and HOAs, and what it's like to live in the Venice area. Now let's get into the top 5 must-do steps after moving to Florida. But first, there's an important clarification on establishing Florida residency. And that is that Florida does not have a 183-day residency rule. You'll often see that mentioned online, but it's just not true. However, many states that people move here from do have 183-day rules. States like New York, New Jersey, Connecticut, Massachusetts, Michigan, and Minnesota, all states that I've mentioned in prior videos because people tend to move here and relocate here from those states. They all apply some form of statutory residency test, meaning you can still be treated as a resident for tax purposes. And they do apply a 183-day rule. Many other states do as well, so it's important to understand your former state's residency rules. New York and California are especially well known for aggressively auditing former residents who claim they've moved elsewhere. So be very careful if you're from those states. Okay, the key point is this. 183-day rule is not a Florida requirement, but it may be in the state you're moving from and can absolutely affect whether that state continues to tax you. Know your former state's rules and take clear steps to cut ties when appropriate. In some cases, selling your former home and maybe renting there instead of owning when you go to visit or stay with your family in the summer months can save a lot of money in the long run. Okay, so now that I've cleared up there are no days required in Florida, let's get started with how you establish Florida residency in the order you should do these steps. So number 1, driver's license, vehicle registration, and a voter registration is a good idea at the county tax collector's office. That's where we do that here. You need a Florida driver's license showing the property address, and a vehicle registration is recommended before applying for a homestead exemption on real property. And I'll say this, if you're claiming Florida as your primary residence, your records should line up. Having a Florida driver's license but keeping your car registered and insured because it's cheaper in another state is a red flag and can weaken your residency claim if pursued by your prior state. Get a Florida license and register your vehicle here to be sure. Okay, now assuming you've done step 1 and you have a Florida driver's license and registration, number 2 on the must-do list, register for Homestead at the county tax assessor's office. But you must have completed step 1 first because you need all that identification showing you do in fact live here or intend to live here. So to qualify for a homestead exemption, there are 2 key dates in the calendar that you need to know of. You must own the property on January 1st and submit Florida Form DR-501, which is the original application for homestead, to the county assessor's office by March 1st. So January 1, you have to own it and live there, and by March 1st, you have to file the form. It must be your primary residence, not a second home or a rental property. So you're not eligible for homestead if you're not declaring Florida as your primary state of residency. As I went into detail in another video, there are 3 key benefits to the homestead exemption. Number 1 is reduction in assessed value, which lowers the amount of tax you pay. Number 2 is the Save Our Homes cap portion, which limits assessment increases to the lesser of 3% or the rate of inflation each year. And number 3 is creditor protection. Your homestead is protected in most cases from creditors who are pursuing you for debt. Number 3 on the must-do list is file a declaration of domicile with the county clerk of the court. And that's, of course, in the county that you're going to live in. This is recommended when your previous home state engages in aggressive tax collection audits on prior residents. Some other things you can do are file your IRS tax returns with the Florida address as your primary, file a permanent address change with the Postal Service, change your bank statement address, show obviously you're going to have utilities at your new place. So just make sure as much as you can you document that you live in Florida. Number 4, insurance update on all insurance policies. Update the information, obviously, with a homeowner's policy on your new place in Florida, you're going to list that as your primary residence. If you have a home in another state and you intend to keep it, contact the insurer and make sure that property is classified as your second home, not your primary residence. This is all, again, about creating a trail and making sure that everything is sending the same message. Any other policies you have, update the info. Umbrella policies, auto, you're going to do that when you get your license and register your car here. And of course, health insurance, you want to update all that information. And just be aware that homeowners and auto insurance policy premiums will generally be higher in Florida. I talked about that in another video. Okay, number 5. And this sounds a little off topic, but it's of course related to my background in financial planning. Number 5 is estate planning updates after change of residency, when you move from one state to the other. So estate planning documents are drafted according to state law, not federal law. So they absolutely must be updated when you move to another state. And I mean any state, not just Florida. If you establish residency elsewhere and your estate planning documents were created while you still lived in the other state, you now have to change them. Okay, update all estate planning documents. This includes will, trust, living will, healthcare proxies, and I recommend doing this with a Florida estate planning attorney, not a general law practitioner. And here's a tip. If you own property in another state, it is highly recommended that you establish the appropriate trust. I say a revocable living trust in Florida and retitle any property owned in another state into the name of the trust to avoid an ancillary probate. And what that means is if you own real property, certain other property in another state, you can be subject to a probate administration. So you might own a house in Florida, you own a house in New York, that would translate to 2 probate administrations. If you put the properties in the name of the trust, that avoids that probate. And I just want to clarify, I am not an attorney. I don't draft these documents. I am a certified financial planner. I was trained in matters of estate planning, used to teach courses on this. You need an attorney to draft these documents. I can only discuss what, I think you should do. And I always say, consult a Florida licensed estate planning attorney for assistance in drafting these documents and retitling out-of-state assets. Okay, don't do it with an attorney from your home state. All right, that's just my advice. Now, one other thing on this, because I see this and hear it all the time, please do not add your children's names to your deed, This can cause a lot of potential problems that I'm not going to go into here, but if your child gets divorced, if they go bankrupt, a lot of things can happen. You could have a falling out, they may not talk to you. Please don't do that. And if you're considering a Ladybird deed, review the potential downsides with a Florida estate planning attorney before assuming it's the right solution. This includes the risk of disputes between beneficiaries after death, questions over who maintains or pays the expenses on the property, and potential creditor issues affecting beneficiaries. These are just a few of the downsides of Ladybird deeds. So my advice is always revocable living trust is the best solution. It costs a bit more money. That's just my personal opinion. Okay, the bottom line is Florida offers some very strong financial benefits and legal protections to residents, but they're not automatic. You have to take a few specific steps for these benefits to apply. Delaying can cost you money or create unnecessary issues later. Like, for example, if you miss the filing deadline of March 1st for your homestead exemption, that means for the current tax year, you're going to pay higher than necessary property taxes in Florida. So just take note of that. My goal with this video is to help you avoid making mistakes and start out on the right foot when you move to Florida. So again, I'm Robin Vakai, the broker owner of Beach Bay Real Estate here in Venice, Florida, and the creator of this channel, Suncoast South. If you found this video helpful, please subscribe to the channel. And if I can help you with your real estate needs here in the Venice area, please feel free to reach out or leave a comment. I do try my best to respond to all of the comments. Thanks again for watching, and bye for now.